Hello everyone. Today we are going to talk about arbitration proceedings. Arbitration is a type of alternate dispute resolution mechanism. Under arbitration, the parties mutually decide while entering into any sort of agreement that they will go to an arbitrator, appoint an arbitrator for resolving their disputes instead of going to the traditional courts whenever in the future the dispute arises. And the reason is very simple, that the Indian courts are overburdened. Right now, there are over 40 million pending cases in the district judiciary alone. So, it's better to go for such alternate methods for resolving the disputes instead of going to the court. The appointed arbitrator passes an arbitral award which is legally binding on the parties as if the court has passed the award itself. The next question is, how does one decide that they would want to go for arbitration instead of going to the courts? For that, the parties make an arbitration agreement or they enter an arbitration clause in their main agreement. I'll show you an example of an arbitration clause. So, this is an arbitration clause. It says any dispute arising out of a relation to the loan, including this agreement or loan document, shall be referred to arbitration to the sole arbitrator appointed by the lender. तो यहाँ पे पार्टीज कह रही हैं कि दे वुड अपॉइंट अ सोल आर्बिट्रेटर जो कि अपॉइंट करेगा लेंडर. So one of the parties is going to appoint the arbitrator. The parties agree and confirm that the arbitration proceeding shall be conducted in accordance with the Arbitration and Conciliation Act 1996 and the rules applicable thereto. The venue of arbitration shall be Noida or Delhi. So the venue is Noida or Delhi. An arbitration proceeding shall be conducted in English or in Hindi language. The decision of the arbitrator shall be final and binding on the parties. Pending the passing of final award, the borrower shall be liable to perform all obligations under this agreement. So this is an arbitration clause under an ad hoc arbitration. Parties can decide in their main agreement that whether they want to go for an ad hoc arbitration or an institutional arbitration. Ad hoc arbitrations are more flexible and cost effective, and while the institutional arbitration may the institution like DIAC or the IADC, they appoint the arbitrator and would manage all the arbitration proceedings for you. So you will have to pay an institution fees so that they do all the work for you. Now the first step is done. You have an arbitration agreement or a clause. Now let's consider a scenario जहाँ पे एक dispute arise हो गई है between the parties. So the second step would be to invoke the arbitration, right? But before that, if it's a money dispute or some subject matter is involved, then you can also go to the court for interim measures before invoking the arbitration. If you think that the other party might run away with your money or your subject matter would be destroyed or ruined by the time the arbitrations are completed. So to secure it, you can go to the court and they will pass a interim measure. So once that is done, so it depends on case to case basis. So if your case requires it, then you may go under section 9 of the Arbitration Act to the court to secure your subject matter or the money involved in it. So now second step is done. Now the third step is invoking the arbitration. So for doing that, you will give a notice to the other party that you wish to start arbitration proceedings for the dispute. अब उस नोटिस में आप बताएंगे दूसरी पार्टी को कि क्या डिस्प्यूट है, कि आप आर्बिट्रेशन प्रोसीडिंग स्टार्ट करना चाहते हैं क्योंकि आपने पहले एग्री किया था. तो आप उस आर्बिट्रेशन क्लॉज को उस नोटिस में ऐड कर सकते हैं. उसके बाद यू कैन ऑल्सो अपॉइंट द आर्बिट्रेटर इफ दैट पर्सन इज नॉट ऑलरेडी अपॉइंटेड और डिसाइडेड इन द एग्रीमेंट मेन एग्रीमेंट इटसेल्फ. तो एज अ मैटर ऑफ प्रैक्टिस आप आर्बिट्रेटर उसमें रिकमेंड कर सकते हैं. यू कैन नॉमिनेट द पर्सन यू वांट टू बी द आर्बिट्रेटर. Now let's assume that the other party is not satisfied with the person you have appointed as the arbitrator, and now you both are in disagreement. So in that case, you can go to the High Court under section 11, and High Court would appoint an arbitrator who is an impartial person for both of you. Once the High Court has appointed the arbitrator, you can proceed with the arbitration proceedings. The arbitrator would call both the parties on the first hearing. After that, the person who initiated the arbitration is called the claimant. So the claimant will file a statement of claims. Statement of claims में आपकी averments होंगी, supporting documents होंगे, annexures होंगे, and on the basis of which you are claiming your rights. Then the other party, that is the respondent, will file the statement of defense. After this, the claimant, if they wish to, they can file a rejoinder to the statement of defense. Once all these statements and rejoinders are filed, the parties will now lead the evidence. They will call their witnesses, examine and cross-examine them. Now the arbitrator will consider all these evidence on record, all these materials, the witnesses and everything, and he will pass an arbitral award. This arbitral award is legally binding on the parties. If the parties are satisfied, they will go for execution. And if the parties are not satisfied, then in case of domestic arbitration, they can go to the district court. And in case of international arbitration, they can appeal to the High Court to set aside the arbitral award. They have a right to file application under Section 34 of the Arbitration Act on the basis of the grounds given under that section. So this is the basic procedure of how an arbitration proceeding is held. There is one other scenario. Let's assume that the respondents never come to the arbitrator. After the notice and the summons sent by the arbitrator, the respondents do not respond to that and do not come for the hearing. So in that case, the arbitrator can pass an ex parte arbitral award after sending the notice to the respondents. This ex parte award will also be final and legally binding on the parties. But if after some time the ex parte party or the respondent they come to the court, they can file an application under Section 34, and if they could prove that they were under some incapacity, then they can get the arbitral award set aside. This is a general overview of the arbitration proceedings, and as you can see that it is a very efficient and cost effective method of resolving disputes.